The court appointment of a guardian is a very difficult matter. In one sense, a family member that has an interest in the care of their loved one can apply to the court to be named as the guardian. And if they have nothing that disqualifies them from that, again, any family member would be qualified, subject to maybe somebody having a greater interest. So for example, a child wanting to be a guardian of a parent, court would appoint that person unless maybe the other spouse wants to be the guardian. And then the court's going to make a determination which person is the most appropriate choice. They'll make a first determination whether or not a guardian is necessary because of their physical or mental condition. And then secondly, who amongst many people that may be applying would be appropriate. Now, there are instances where no family member is able to step forward and be a guardian, and at that point in time, a public guardian may be appointed. Somebody that is a volunteer. In Franklin County, for example, there's a volunteer guardianship program that is got limited resources, so the court doesn't like to tap it unless they have to, but that is an available resource. There are also similar situations throughout Ohio and elsewhere where volunteers, charities, boards will have somebody that can come forward and be a guardian. But again, these are limited resources, so the court does want to find family members or friends for the family, for that matter, if at all possible. When somebody is in a situation where they are no longer mentally capable, or physically capable for that matter, of handling their own affairs, for one reason or another, and we have a physician or medical professional that will be willing to sign a certificate saying this person, for whatever reason, is unable of handling their own affairs, then a guardianship can come into play to provide somebody with the tools necessary to assist that person. There are two types of guardians. Sometimes they are mixed together, but the first type is a guardian of the person, and the second is a guardian of the estate. A guardian of the person is somebody that the court has put in charge of making healthcare decisions for somebody else. A guardian of the estate, on the other hand, is somebody the court has put in charge of the financial affairs of that person. Again, sometimes a person will serve as both guardian of the person and estate when there is money involved that needs to be managed, as well as healthcare decisions that need to be made. The court always is sensitive of the fact that a guardianship is a very restrictive act. And because of that, there is a structured law in place, a process in place, that when somebody asks to be appointed as a guardian for somebody else, one of the first steps in the process is that the court will send to the prospective ward, the person that we're seeking guardianship over, they will send to them a court representative that's going to do an assessment as well, and they are going to provide that person a notice of their rights. Their right to have counsel, for example, the right to appear at the hearing, and the right to have the applicant to be appointed as guardian prove to the court that there is no other less restrictive option available to take care of this person's needs than the guardianship. So for example, if there's a valid power of attorney in place or money was in a trust, then we may not be in a situation where a guardianship is necessary. So these are the type of things that the prospective ward will be informed of by the court as their rights. Then it's their choice whether or not they wish to enforce those rights, seek their own counsel, and to contest the application for guardianship. Once a guardianship has been established, there is an oversight that the probate court does conduct into the affairs of the guardian. At one level, with a guardianship of the person only, that consists of training that the guardian needs to certify that they have conducted and continue to do. And they also have to report back to the court on an annual basis of what they have been doing with the ward, how many times they see them, where the ward is, what the ward's condition is, whether or not a guardianship is still necessary. This is a guardian's annual report that they need to file. If there is a guardianship of the estate as well, then in addition to the report of the condition of the ward, the guardian of the estate has significant responsibility with regard to seeking permission from the court before expenditures are made and reporting back to the court all the transactions that happened in the guardianship during each year in the form of guardian's account. And that's the tools that are used for the court to maintain some level of oversight over a guardianship. Once the guardianship has been established, it will continue in place until such time as either the ward, the person that's subject to the guardianship, has passed away, or the conditions that led to the need for the guardian have cleared up. So, for example, if somebody had a physical condition that led to the guardianship being necessary, maybe to make healthcare decisions for them, and those needs are no longer there, the person's recovered from whatever that condition was, then the guardianship would be terminated by the filing of a notice to the court that the reason for the guardianship has ceased to exist. But other than that, the guardian will continue to be in charge until the end of, again, the disability. So when somebody is facing a situation where they have mental deficiencies or decline, and they want to plan for it and be aware of it, there basically are a few tools that are out there other than the straight guardianship. One tool is the living trust that assets can be put into, and then the trust will manage the assets if somebody does have an incapacity issue. That person can serve as trustee until such time as they feel that they're not fit, or somebody that's also involved in the trust certifies that they're not fit. So that can be done to maintain privacy. That in combination with a healthcare power of attorney and perhaps a designation for mental health treatment as well would establish a structure that would allow us to avoid guardianship for the most part. Outside circumstances may drive that, but for most people that would be enough. And then there's another approach that people do take, and that is what's called a conservatorship. And in Ohio, a conservatorship is essentially a voluntary guardianship, where I, as the person that will be subject to the conservatorship, say, I think I need some help, and I'm willing to have somebody be my conservator, and I'm going to give them that power. I do it through the probate court, so it's a little more difficult for me to change my mind than with a power of attorney, but it does create a structure that does give somebody else, the conservator, the ability to make decisions on my behalf. So it's not uncommon to have the situation where somebody is involved in a guardianship and the guardian themselves pass away. And what happens next, right? So first of all, having already established a need for a guardianship, part of the process does not have to be repeated. But what will have to happen is somebody will have to apply to be appointed as the successor guardian. And just like with the initial appointment of a guardianship, whoever has got an interest in that person's well-being can apply, and the court's going to determine who is the best applicant. And then they'll take over from there moving forward. Now, frequently some people think that if somebody was the guardian, they should be able to name who the successor guardian is. And that can happen. It's not something that will be controlling, that the court's going to have to follow that directive. But if I know I'm going to pass away and I want to make sure that things are set up for whomever is going to take over as guardian for whomever my ward is, my influence, my statement that this is the appropriate person will be given substantial weight by the court. I've been involved in the probate process since 1990. And over the years, I've had many, many situations where people have started estates, guardianships themselves. And although on the outside looking in, it seems like it's a fairly easy process because it's just a bunch of paperwork, but the devil's in the details. Many times I have found that the people that have tried to do this themselves, by the time that they get to a spot where they don't know what they're doing, and the court has to bring an attorney in to help them clean up the mess, they end up spending a whole lot more money than had they just started with an attorney in the first place. There are lots of little intricacies that are involved in dealing with people's affairs, things that you don't know about, things that are not in any type of book. And most people just can't navigate these. And unfortunately, the courts are not set up to be in a position where they can assist people through the process. That's the job of the lawyer, and that's why we're here.